Hi, everybody. I'm Chuck Kruger. Welcome. And like Michael said, this is Children of Money, Wage and Hour Compliance, the third webinar of this series. And let's go into our disclaimer. Just to remind you, as always, that we're not your attorneys or advisors, and you can't go out and make important business decisions based on what you learned from this webinar today. This is just general information and general knowledge to help you select and work with an advisor of your own choosing. Also, we will be talking to some extent about these slides and we'll be going through them. So you may want to take some notes or refer to the slides themselves as we go on. They should be online for you. Also, regarding the slides, there's more about financial poise on slide number 52. And also, there's more about us, the panelists, on slide number 35 through 38. And as always, our panelists are Max Barrick, partner of the Garfinkel Law Group, Helen Block, law offices Helen Block, and Amit Bindra, of the partner with the Prinz Law Firm. Again, I'm Chuck Kruger. I have my own management side labor and employment law firm. And if you're attending the live premiere of this webinar, you can submit questions using our web portal. We'll be monitoring it. And if you're watching this on demand and you have questions after the webinar, you can send an email to info@financialpoise.com. Include your question, the name of the webinar episode, again, number 3, wage and hour compliance, and we'll do our best to get you an answer ASAP. Also, thanks to our sponsor, National Law Review. You can find out more about the National Law Review on slides 3 and 51. So with all that out of the way, let's get going. Helen, let's start out with the macro environment here, or meta sort of question. How would you describe the United States right now in terms of wage and compliance laws? Is there sort of like a zeitgeist or general philosophy relative to wage and hour here?
Yeah, generally wage and hour claims in the employment context are usually one of the easier claims to establish. Most employment law matters are rather amorphous. They're not black and white at all. It's a he said, a she said. They're very, very challenging. When it comes to wage and hour, again, nothing under the law is black and white. So I don't want to say this is black and white, but it's the closest to black and white you're ever going to find, because we have very robust wage and hour laws in the United States. And among practically each and every state in the union, there are additional wage and hour laws. And usually those wage and hour laws, as a general principle, are exempt even, let's say, from waivers and release agreements. So you cannot contract away the requirements under wage and hour laws with your employees. So that makes it very, very robust. The fact that employers, if an employee is not exempt from overtime, you better pay that overtime. Otherwise, there are going to be steep penalties. If you don't pay minimum wage, you better pay it, or otherwise there are going to be steep penalties for failure to pay. And the reason why these issues are a little easier to determine than some of the other kind of employment laws is that there's usually a paper trail. Did you pay the wages or not? You know, there could be bank records, there could be checks, time records. There's a little bit more of reporting and a record keeping with wage hours and, let's say, other things, because there are mandated reporting requirements and you're supposed to keep track of wages. So it's a little bit easier of a claim to establish, and there are a lot of penalties around it. And there are a lot of laws, again, that have to do with payment of wages and hours to employees, penalties when there aren't, and it's a matter of law. You cannot contract out of this law. It is strict liability if you don't pay.
There you go. I was just going to say that.
Yeah.
Legally speaking, strict liability. Okay. I was waiting for those 2 words. Okay.
Right. Which strict liability, which basically means is that you can have a million excuses in the world. Like, you know, my house burned down. The law doesn't care. If you didn't pay the wages, you owe those wages. And that's what strict liability means. You are strictly liable. It doesn't make a difference what the excuse is for why the wages were not paid.
Great. Thanks to Helen. That was terrific. Amit, so I think Helen alluded to the Fair Labor Standards Act, the FLSA. What does that require of businesses relative to overtime? And what are some of the monetary thresholds that we're talking about?
It's a great question. And to Helen's point, for the most part, you got to pay people for their work. The
Yeah.
nuance with the FLSA comes into, are they exempt or non-exempt employees? Are they covered and eligible for overtime or not? Covered non-exempt employees have to receive time and a half, their regular rate of pay, when they work over 40 hours a week, where the devil's always in the details. And so the question becomes, are they non-exempt? And then what is the base pay? How do you calculate that? Which is essentially your question. But really it would be, if you're a regular hourly employee, let's say you're making slightly above minimum wage, if you work more than 40 hours a week, you're entitled to time and a half for your overtime wages.
By the way, there are a few jurisdictions that have double time, like on weekends, things like that. So I know
That's
California, I think, is one.
Yeah, that's a great point, Chuck. I think companies also have to be thoughtful about the interplay between state and federal law.
Yeah.
And sometimes too, the state minimum wage is usually higher than the federal minimum wage.
Okay, it says so. Max, can employers just pay everyone a salary in order to avoid FLSA? Or what about just classifying everybody as a 1099? Is there any can you think of legitimate ways that an employer can avoid overtime?
Sure, there are a lot of legitimate and illegitimate ones. It's just a question of what your risk tolerance is, I guess.
Yeah.
Um, it seems like half the time I run into these, I get the defense of, well, my accountant told me I should do X. And it's like, well, I'm sure they're a very knowledgeable accountant, but they're not an employment lawyer. So maybe get a second opinion next time. No, so the answer is you really just can't announce salary or contractor. What you put, the FLSA is one area of law where really what you say in writing is just not that important relative to what you actually do in practice, and how what you do meets the different legal standards exist. So, in employment law, there are a lot of different standards for what constitutes somebody who's an independent contractor versus an employee. There are different tests employed under different laws. At least the last time I checked, I know this sometimes is one of those standards that yo-yos depending on who's in office. But there's a 6 or 7 factor economic realities test that is employed for FLSA claims, and I think the IRS uses their own version of an economic realities test to make that
The key
determination.
words are economic reality. So yeah.
Right. And so, and those factors are not what did you write down or what do you feel like they ought to be, or do you want to pay them overtime or
Yeah.
not? They have to do with items like, are you doing something within the core functions of the business? Um, for anybody who took Econ 101 at some point, everybody always used to use widgets. Widget factories is the example. So for the widget factory, are you making widgets, but they just don't want to call you an employee and pay you, benefits and by the out, overtime? Or are you the web designer they brought in to do a project for them on a one-off basis who has their own business? That's a real independent contractor, not somebody who's performing the core job functions of that business, not working other places, having no control over their earning capacity other than by working more hours. They don't get to set rates. Um, they don't control the uniform. They're held out as part of the business. These are all different iterations of those factors. None of them is dispositive, and you sort of throw them in a blender together and say, okay, if we weigh all of these things, am I a contractor or am I an employee? I will tell you, the road is littered with people who maybe even had good intentions about it, and thought there was a basis for calling somebody a contractor. On the defense side, I actually worked on a matter once where it was some sort of a construction business, and they hired a bunch of contractors, or what they thought were contractors, had them get workers' comp insurance, had them get subcontractor agreements, sometimes sign independent contractor agreements, and thought they were paying a fair rate and they were all set. You know how these things go. One thing leads to another. Somebody gets fired, gets sour grapes, justifiably fired if memory serves. And the next thing you know, they're hit with a class or collective wage and hour case over overtime pay because they weren't tracking hours and these people were really only working in one spot. Now, as to the salary part of it, um, you can call folks what you want, but there are regulations and exemptions galore throughout the FLSA. It's one of my favorite employment laws for that reason, because there is such a robust body of law that exists that you don't actually need to be a lawyer to read through. I mean, it helps, but it is designed in a way where non-lawyers can navigate the FLSA at least a little bit. The Department of Labor puts out some really useful regulations that are accessible to the public that give real-time examples of what does and does not count, that will walk you through when somebody can be considered a salaried employee. But, to keep in mind, if somebody is salaried, it cuts both ways. You're not paying them overtime, but then you need to pay them no matter what, or they're not really a salaried employee. So just because you call it a salary doesn't really get you over the threshold. There are still minimum amounts of payment you have to meet, and you have to actually truly treat them as salaried. You can't deduct pay for hours missed. They take a half day off. If they're no longer working for you, you don't have to keep paying them. But so, there are no get out of jail free cards here. There is no panacea that just allows you to circumvent overtime. You really need somebody, an attorney ideally, who knows this law, can look at job classifications, not just what's on paper, but what is actually happening in real life, and saying, yeah, you can get away with naming this person exempt for these reasons, or you know what, you really ought to pay them time and a half or cut their hours, like make sure they're not mowing more than 40, because you've got some exposure.
By the way, you mentioned the Department of Labor, U.S. Department of Labor. They also put out a lot of publications or guidance on job classifications themselves. So, and they're really
Yeah.
useful for that purpose too.
They have fact sheets. If you Google any of the
Yeah.
exemptions, like salaried, exempt, administrative exemption, a lot of the white collar ones or even blue collar ones, they have these great fact sheets that are not in legalese. They walk you through the elements. They give you examples. They'll give you typical problems people run into. And they'll even give you kind of the exception to the exemption. Like, well, in this industry, it's A, B, and C job. But so, like, for example, the Motor Carrier Act, folks working for over-the-road trucking or logistics companies who drive the vehicles and are working in safety affecting activities are typically exempt from overtime pay. So drivers, co-drivers, mechanics, loaders, mechanics helpers. If you're putting your hands on the truck in a way that affects safety in some way, you're probably exempt. However, that fact sheet also has an exemption to the exemption for dispatchers. So dispatchers are not inherently exempt there, and they tend to fall, in a weird nether region within that. So those are useful fact sheets and will usually help you at least be in the right area to stay out of trouble.
Thanks, Max. Great.
Let's circle back
Helen,
what
I'm
Max
sorry?
just circle
Sure.
back to Max said at the beginning of that too. You want to be cautious as a business about the contractor test because every agency uses a different test. So the IRS, the State Department of Labor, the Federal Department of Labor, workers' comp, unemployment, they all kind of have a different way to approach this. And messing it up with one agency can mess it up with all agencies. So I think it's just better to be cautious on independent contractors versus employees to avoid a bunch of headaches across the board.
And
Well,
go ahead,
I'm
Chuck.
sorry, yeah, it's better to take a conservative approach to this.
Well,
Uh,
and when in doubt, like, I mean, do consult with an attorney, but like I've found as a plaintiff's lawyer, like the companies that get sued are usually the ones that not just like cut corners, but will err on the side of being stingy. Like if there's a close call and people feel like they're treated fairly, they tend not to want to sue that company. If they're like, yeah, it's a close call, but you know what, they were nice to me, I don't really want to make trouble for them. That is often the calculus. So, don't be short. I guess it's like a long way of saying, like, be careful about being short-sighted on it because you might save a couple dollars here, but if you're not careful, it may end up as a much, much bigger exposure down the road.
yeah, angry people get desperate, and desperate people will do anything.
Right.
Great. Helen, what are some of the most common or prevalent exemptions to the FLSA or other wage and hour laws that you've seen?
Sure. So one of the things that I have to mention upfront is that the Fair Labor Standards Act does have a number of exemptions, which I will go through. And I will piggyback off what what Max and Amit were discussing, which is like it's this two-part test. So you have to keep that in mind. You have to fit this two-part test in order to fit under one of these exemptions. But my caveat is that just because it's exempt under the Fair Labor Standards Act doesn't mean it's exempt under your state law. And I'll give you one example in particular. One example in particular is outside sales exemption. So for instance, or I shouldn't say that, actually, the better example is really the highly compensated employees. That's probably the best example. So for instance, under the Fair Labor Standards Act, if you have someone who is highly compensated, meaning they make like over $107,000 approximately per year, then they are exempt from overtime. The reason why you have to be careful with these exemptions is because that might not be exempt under a state law. Okay. So for instance, if you make over $107,000 a year under federal law, under the Fair Labor Standards Act, well, you might be exempt. If let's say you're paid those $107,000, not in some sort of a salary, but based on some sort of like hourly determination, even though it's a lot, like maybe you make like $200 an hour, the mere fact that you're paid per hour might not allow you to be exempt under another state's law. So just keep that in mind. But as a general principle, what we generally consider exempt are those who pass the two-part test. You have to pass that two-part test as, the others have mentioned, which is the duties test, which is multifactorial. And also you have to pass the salary test. So assuming you pass the duty and the salary test, what are some of these duties that will make you exempt? So for instance, a professional, if you're a lawyer, if you're a doctor, and the majority of your duties as part of that duties test is really in your profession, where most of the work you're doing is not clerical, but it really is engage in the practice of law, or it really is engage in the practice of medicine and not something clerical, and you receive that certain set salary that's more than the minimum requirements, then you will be exempt from overtime. You'll be considered exempt. Some of the other common exemptions are computer employee exemption. So there's certain types of computer type of skills, not someone who's just sitting there doing data entry all day. That's not going to make you exempt. But, for instance, if you are a skilled computer analyst, a skilled computer programmer, software, that might make you exempt under the Fair Labor Standards Act. Again, check your local state law. There might be a difference. Administrative and executive, which sometimes, a person can fall under one of these, a person can fall under both. But essentially, if you exercise, discretion, independent discretion and judgment with respect to your job, you're really the cook, chief, and bottle washer of that business. You decide who to hire, you decide who to fire. You are the one who is ordering, all of the supplies without having to go to a higher person of authority. Then you might fit under the administrative exemption, or you might fit under the executive exemption under the Fair Labor Standards Act. So these are some of the most common exemptions under the Fair Labor Standards Act and under, a good amount of state laws. Now, I will say though, oftentimes state law might incorporate into its law the Fair Labor Standards Act, and basically will say, well, what is exempt under the Fair Labor Standards Act is exempt under the state law. That's not true in every state. So you really do have to check your state law.
Thanks, Helen. So, Amit, relative to timekeeping, this is always an interesting topic. And I always find this very contentious among employees and employers. Can an employer just tell their employees to keep track of their own time and then submit a timesheet each week or every 2 weeks, whatever the pay period is? The pros and cons of that.
So I guess yes and no in a way. Obviously employees should track their time, but employers have to make sure that it's going to ultimately be on them. If there's a dispute where an employee says, I was working more and you should have known, ultimately the employer is going to be on the hook for that. So that's not to say like you can't require an employee to keep track of time, like when they come in, when they come out, that type of stuff. But the employer has to make sure there are record keeping and their record keeping is being done. And sometimes you'll see this play out in different types of cases where someone will say, look, I was sending out emails late at night. You should have known I was working and I'm now eligible for overtime. There is also, and sometimes there can be issues as to like the stuff you do before work. Does that count as working on the clock or off the clock? But pragmatically, the employer is going to be on the hook if there is a dispute about how many hours the employee worked, if the employee can reasonably demonstrate I was working more than 40 hours a week.
Is there any like best practices that any of you've seen, or like a best way for timekeeping, biometric, or just punch clock or whatever?
Loaded question.
Yeah.
I
So
think
one of those old timey clocks with the punch and the whistle on the end. That's the best.
the payroll
Yeah,
company,
the one that moves backward too. Yeah.
Yeah, and whistles when the shift ends, like in the coal mine.
payroll companies do provide timekeeping software so people can clock in and clock out. You have to be careful depending on the state you work in, or the state you operate in with those timekeeping devices. So for example, Illinois and Texas have biometric privacy acts. So if it's a fingerprint scanner, a biometric scanner, that could be an issue for based on state law in those two jurisdictions. So that's just something to be cautious about from a timekeeping standpoint. But those are some things companies will do. They'll use like clocking in and out devices as a way to figure out how many hours people are working. I think the other thing to be thoughtful about too is if you are giving people devices where maybe they have access to Slack or email, how that plays out too, because that could create other overtime issues as well.
You ever see a situation where employer has their records, employee has their own records, and the judge or excuse me, like the agency has to decide, who's is more credible? You ever see issues where that
Yeah,
arise?
you see those types of issues. The bigger issue I see is only the employee has the records. And so then the employer doesn't really have a way.
That's a worst case scenario for
Yeah,
employers.
exactly.
Oh,
Yeah.
Yeah, the employee will say, hey, I was working this amount of hours, or you should have known, and the employer hasn't maintained accurate records. When there is a dispute, then it becomes, I guess, a fact-based discrimination to some degree. Yeah.
What I was going to say is if they don't keep the records, then it's almost like a burden shift. There is a real concept. I mean, yeah, like that at that point, then the employee, at least in our jurisdiction, Seventh Circuit, there's pretty robust case law that at that point, if the employee can give like credible and consistent testimony as to like ranges of time typically worked, that's going to just straight up carry the day because they biffed the record keeping requirements. So, I mean, if you don't keep those records at all, and it's just one person's word against no documents that the law requires, it's really hard for the employer to overcome that.
I agree. Yeah. I think
If
when
you get
meeting
if you
record,
get records from another employee or an ex-employee or something like that too, or some sort of sworn testimony, whatever. So
Yeah. I mean, the limit to that would be like they can't just produce, like there's a decision in our jurisdiction, Seventh Circuit, where it's like somebody generated a spreadsheet just to say it's a spreadsheet, and they're like,
well, yeah.
yeah, like it's nice you have a spreadsheet, but that doesn't tell us anything. Like you got to have something.
I've seen employers do that too, though.
Oh
And
yeah, I mean,
and it's after the fact. So what good is this going to do me?
well, I had one time where it was a restaurant and like the hours they were doing something like shift pay. So the restaurant just sort of decided there was a set amount they were willing to pay people to work that amount of time, not in tips, which is not a thing under the law like the FLSA. And the spreadsheet I got, I'll never forget on those cases. I was like, well, this place closes at 10 or 11 o'clock. But according to these records, these people were working at like 3 and 5 o'clock in the morning on a consistent basis. That doesn't make any sense. Like,
Yeah.
so it's, you just keep in mind, like the old adage of, like I was taught by my first boss, anything you do in law, think about how it'll look in the cold, hard light of a disciplinary hearing. But in these cases, sometimes I'm like, how is this evidence going to look in the cold, hard light of like in front of a jury? Is anybody going to buy this or are they going to laugh you out of the courtroom? Because if it's the latter, strongly reconsider what you're doing.
Well, yeah. I mean, you get into like legal tactics, and because for me as a defense attorney, it's like I'm not going to want to take this or introduce this as evidence, or at least I'm not going to try to defend this. I mean, so if the plaintiff wants to harp on it, I'll let them, and hopefully they'll make a mistake, or there'll be gaps in their explanation of this, so that the jury is not going to buy it as much. But I don't want to touch this with a 10-foot pole.
Well, and this is the one area of law and employment that I ever really see summary judgment consistently granted on the plaintiff side, right?
Oh
Like,
yeah.
discrimination lawsuits, whatever, there's no guarantee you're getting a trial. But I see employers lose these claims before trial pretty consistent. Like, if you're not careful, you can lose real quick in these cases, and it gets expensive very quickly.
Well, you have to question usefulness of filing for summary judgment as an employer in that situation anyway. I mean, it's what would be the point?
Well,
So,
I'm
and
saying
just
the
with the
opposite, that
way,
plaintiffs can win summary judgment in
oh
FLSA
yeah,
cases, not easily. There's no such thing as easy in law, but you know, it's sort of like Helen said at the beginning, there's strict liability. Some of the time there's not much to talk about. It just happened and you're just cooked.
yeah. Thanks. Uh, actually, Max, let's stick with you now.
All
Um,
right,
can
Mr.
thanks. Can the business operator deduct missed time or like discipline salaried or exempt employees by docking their pay? I mean, what can they do relative to deductions for like discipline or performance based reasons?
You want to be really careful with that. The it this touches on what I said earlier. If you're a salaried employee, then you're supposed to be getting paid that money really come hell or high water. Like that's the benefit of being salaried. Sometimes you're going to work more, sometimes you're going to work a little less. It's understood. Um, hopefully the employer's not taken advantage of and we're not dealing with time theft, right? Like somebody who shows up and does nothing. Um, but generally speaking, it's supposed to be paid. Um, if you start making improper deductions, like I don't like what you did today, I'm docking your time, you're not getting paid for this, or oh, you called in sick or you left early, so you're not getting paid for that. If you're not careful, you may lose the ability to call somebody a salaried exempt employee because you're not actually treating them as salaried. You are calling them salaried and you're ostensibly paying them the same amount, except if you decide you don't want to. And in that situation, justified or not, you haven't. So the Department of Labor does have some exceptions where deducting from pay is potentially permitted. So let's say you're out of PTO, you've used all your vacation days, you've used all your sick days, and you need to take a day for personal reasons that's not covered by the company's leave policies or any other protected leave policies under law, because some states have those, then you can take it. If there is a full day absence for sick or disability under a bona fide leave policy after that leave is exhausted, like I started to allude to, um, there are certain types of offsets that are permitted. Penalties for like major safety violations can at times be permitted. Um, Unpaid disciplinary suspensions of multiple days for certain workplace conduct, your first or last week of employment where maybe you don't complete a full work week. So let's say your last day is a Wednesday, they don't have to pay you through Friday or whatever the end of that work week is. And unpaid leave under the FMLA. Let's say you have a baby, your spouse has a baby, you have a family medical leave issue, which we will get to at a later webinar that folks should turn into. Then you're allowed to take that time away. What you cannot do it for is like what I said, partial day absences, just I don't think you worked enough today or you're lazy, I'm not paying you. Minor misconduct or lateness, hey, you were 5 minutes late, you're losing, X amount. You're basically just treating them as hourly then, or inconsistent disciplinary policies. If you do it systemically or on a regular basis, you run the risk of losing that salary exemption. So, um, if it were me, I would say really think hard about whether or not you really need to do that with someone.
So thanks, Max. So Helen,
Yeah.
here's I think one of the more difficult topics nowadays, and I think it's going to get really contentious uh, very soon or within the next year, within this year. Um, what's going on with tip employees and like tip credits, tip pools? What do we need to know about them?
Yeah, this is a hot topic around the country. For instance, we've heard President Trump talk a little bit about it, not specifically the tip credit, but certain tax laws with respect
Exactly.
to tips. But around the country, there has been noise, and in some cases, it's more than noise. There new laws have been passed getting away from the tip credit and not allowing a tip credit. So, what is the tip credit? Every employee, whether they get a tip or they don't get a tip, has to make at least minimum wage under that state's law for all hours worked. That's the bottom line. With that said, if there is a tip credit in place under the Fair Labor Standards Act, for example, and so I'll stick with federal law, that means that if an employee gets tips regularly, and the way the Fair Labor Standards Act talks about tips is that the employee generally receives at least $30 a month in tips, they can be considered a tipped employee. And in that case, the employer does not have to pay as much per hour, the theory being they get enough tips to make at least minimum wage and generally more than minimum wage. But again, employees must get at least minimum wage. So if they're not getting minimum wage between the amount they earn in tips and the amount the employer pays them per hour, the employer has to make up the difference and pay them at least a minimum wage. But assuming the employee makes, more than $30 a month in tips and more than minimum wage, taking into consideration the tips, then the employer does not have to pay them the full minimum hourly wage for that time worked. And then there are some things called a tip pool. So the Fair Labor Standards Act allows employers to require employees to share pool or tips with other eligible employees. What I mean by other eligible employees is it has to be those who are not management, supervisory level, not the owners of the restaurant. So the owners cannot be sharing in these tips. Managers cannot be sharing in these tips, even if, let's say, the restaurant, and I'm using the example of a restaurant because that's where it's most common. Certainly there are tips in, other types of industries as well, hotel, whatnot. But generally it's most common in restaurants. So for instance, if the restaurant is a little short and a manager pitches in and busses some tables, that does not make them eligible to participate in the tip pool. If the majority of your tasks are managerial, you're going to be a manager and you cannot share in that tip pool, but you can have a tip pool in which, these tips are shared among all the tips that come in, go in the tip pool and then shared among the non-managerial employees. So that's essentially what a tip credit is and what tip pools are. And again, pay attention to your state's laws and not just your state, the local jurisdictions. It's
Yeah.
the local jurisdictions. Some of them are doing away with the tip credit and requiring employers to pay the full minimum wage for all hours worked. And what you're starting to see, let's say if you go into restaurants, is there are other surcharges and fees that are being added to your bill to take into consideration that now these employers in these restaurants that in the past traditionally did benefit from the tip credit and now have to pay the full minimum wage. And so they're making it up in other ways. So message for consumer, pay attention to your receipts and bills when you go to places where traditionally one pays a tip.
Thanks, Alan. So, Amit, another question regarding the calculation of overtime. If a business offers bonuses or performance incentives to their non-exempt employees, they're basically their overtime eligible employees, how does that impact their rate of pay, especially if they work overtime?
Well, it does impact it. This is one of the trickier parts of calculating overtime. We talked a little bit about first figuring out whether someone's exempt or non-exempt, but then the other situation that arises that complicates things is figuring out what the regular rate is for calculating overtime. So that could include non-discretionary bonuses, incentive pay, commissions, differentials in shift, retroactive pay increases, maybe other board and lodging, depending on the type of job. So that's where I think employers have to be careful about calculating that. And typically, if there is a mistake, it's going to be an across the board mistake. The regular rate of pay won't include certain things. So PTO, gifts, reimbursements, discretionary bonuses, retirement plan contributions. Those won't be included as part of calculating the regular rate of pay.
Thanks, Amit. Max, something, and this always comes up with employers on-call employees. What are the issues that employers should be aware of when it comes to the hours worked for employees who are on call?
So I think the general framework to start with is what sorts of restrictions are put upon that employee within the context of being on call. Or is it, I come from a medical family, so, and I old enough to remember what beepers were used for, and right, like,
Hmm.
my medical parents would have, their beeper. It's like, I gotta, I'm on call, I gotta go make a call, whatever. So, is it like, hey, you can be doing anything, you just, there's no restrictions on where you are. You have a lengthy time to respond to the on call. You're rarely called in. You're not restricted to staying on employer's premises, and you can use that time for really whatever you want. You just need to be, available within an hour or something like that. That's not going to be compensable on call time. I think a lot of the times you see this, it's one of the odd situations you'll see an unpaid overtime issue in public employers, which I just find as a general matter, a lot of public sector workers are unionized or, have tend to be well taken care of in that right. But you will occasionally see FLSA claims brought about on-call time for like firefighters or paramedics, what have you. My internet's freezing up.
A little bit from time to time.
Okay. That's less than ideal. Um, let me know if you guys can't hear me. When it is compensable, think like you're stuck on premises, you can't leave. There are restrictions on your ability to leave the place. If you do leave, you can't go far. You need to be available immediately. You can't engage in personal activities. You can't go to sleep. You can't shower. You can't leave the property. You can't drink alcohol because you need to be available and both in mind and body right away.
Yeah.
And you are frequently called in a disruptive way. So where I've seen this before is like engineers who work in facilities where the plant breaks down regularly. And when that happens and they're on a shift, they have to drop what they're doing immediately and come running or the whole factory shuts down. You're not really free to leave. You're not really free to take a break. You can be called in at a moment's notice, and there's just no freedom of movement. Situations like that, they're going to need to pay you very likely.
Okay. Good,
And I
thanks.
guess one other thing is like, even if the on-call time itself isn't compensable, anytime you spend answering work communications, traveling to a job site and doing work, then you start talking about compensable work time.
Was somebody else going to say something or? Okay. Um, Helen, this is another, we're getting some of the more difficult topics today. Waiver agreements or arbitration agreements relative to pay disputes, and voiding class action disputes. Well, what's up with that now? There's been a lot of changes over the last 10 years. Where are we at?
So basically, under our various laws, and I alluded to this in the beginning of my remarks, there's some things that cannot be waived as a matter of right, such as entitlement to pay. Another one of those things is workers' compensation laws. One cannot waive their entitlement to their rights under the various workers' compensation laws around the country. People have an absolute right to their wages. They have an absolute right to file for injuries if they got hurt on the job, if it arose out of and in the course of their employment. Folks have a right to apply for
Unemployment?
yes, thank you. I was looking for the word when they lose their job, unemployment. Thank you for reading my mind in that respect. And in addition to some of those rights that we absolutely have, some things are not subject to an arbitration agreement either, such as sexual harassment. And that's something that was signed into law with the last administration. Now, with those caveats aside, you can have waivers with respect to certain other kinds of laws and requirements. For instance, you can have, we see oftentimes when someone is separated from their job and they're offered a separation package, they're asked to sign a waiver and release of claims in which they agree that they're not going to sue the company, assuming they accept the contract. They're not going to sue them for breach of contract. They're not going to sue them for, let's say, discrimination. Now, even with that waiver and release of claim, one always has the right to petition the government. So again, even if you sign a release of claim saying, hey, I'm not going to sue you in court for discrimination, or I will agree to arbitrate certain claims with the company, you still have an absolute right to petition the government to, to complain about discrimination or harassment or unlawful conduct that you believe is unlawful in the workplace. So again, you can't have like a blanket waiver, release, or arbitration agreement with respect to everything, but you can have it with respect to some things, including in some instances, class actions.
How much does income factor or the amount of compensation play into this? Because I've seen like with I think the standard bearer for this was Jimmy John's, and they had like years ago they had like the non-compete and all the waiver stuff for like their lowest paid employees.
So
Maybe one of my esteemed colleagues, can chip in on this one. I don't know if there is a minimum with respect to
Well, there's no like minimum threshold, but I mean,
yeah, the arbitration agreement that I wasn't familiar with. But
Yeah.
so for instance, there are some laws that go into non-compete, non-solicit, that are state by state, again, not national, that if you don't make a certain income level, and I think this is what you're getting to, Chuck, if you don't make a certain amount of money, such as Jimmy John's, where these sandwich makers, were making
Sandwich artists, Helen. Sandwich artists.
sorry, excuse me.
artists.
Sandwich artists.
If they're artists, wouldn't they be exempt?
Just like, it always cracks me up. What do they call the people who like are bartenders? They call them mixologists.
Oh, mixologists, yeah.
These
Wasn't
fancy,
that also the barista thing too?
yes,
I mean,
these fancy terms. Yes. Thank you. I want to, refer to these folks with their,
but I
proper
mean,
titles
but
or
also,
jobs.
but also, I think what I was getting at too is that from a income standpoint, I mean, or from a benefits versus cost standpoint, especially for an employer, from their perspective, how much does it really matter to like find somebody who's making like $20 an hour, the minimum wage?
They're not going to hold up. So first of all, there are some
Yeah.
state laws that absolutely ban them unless you're essentially, professional making a certain amount of money, or at least someone making a certain amount of money. You cannot have a non-compete or non-solicit. But I would go out on a limb and venture to say, even in those states that don't have laws with minimum wage thresholds, there's going to be a general principle in every state that a business needs to have a legitimate interest in upholding their non-compete, non-solicit laws, and it is not going to cut it. I can go on a limb to say it is not going to cut it for a minimum wage worker who, even if they have a fancy title like a sandwich artist, they're not going to be able to preclude them from going, let's say, to Jimmy John's or Subway's or Burger King or whatever else the case may be, if they truly are, a low wage earner. The company's not going to have a legitimate business interest. They're not going to be able to show that it was what they were doing is so unique. How they cut this sandwich, how they put on the lettuce and the tomatoes and the special sauce is just not going to cut it, and it's not going to be enforceable.
Yeah, and just waiving any right at that income level is just, I think courts are and regulatory agencies are gonna look at it, look askew at it. Just be like, how does this help? Who's benefiting from this? It's just the employer.
Right.
yeah, and to
I
Helen,
mean, you were gonna say, yeah, okay.
yep, several states, what they've done is they've tied whether or not a non-compete is enforceable to someone's income level. Some states have tied it to FSLA standards. So those can be interplayed in the context of non-competes. From an arbitration agreement standpoint, some states have their own laws as to what is necessary for enforceable arbitration agreement. There's a different federal law on that. Illinois, for example, it's not clearly developed, but there's some case law that like you need sufficient years of employment for an arbitration clause to be enforceable, though that hasn't been too fleshed out. But I'm not aware of any law that says you can't have an arbitration agreement if you make minimum wage. Sometimes companies will do that because they want to hide in class action waivers. as a way to prevent people from doing collective actions.
But be
Or
careful
if,
in that. I mean, I think, I'm sorry, Chuck, go ahead.
I was just gonna say too, or if you offer them a sufficient consideration up front, or maybe in installments over time,
Yeah,
it
that
might
could
be
be
more
a way to
enforceable.
actually change the dynamics for arbitration, the enforceability of an arbitration clause. With a non-compete, if you're in a state in which there is a salary threshold, I don't know if you can resolve that through additional consideration unless that monetary number impacts someone's total comp for that year.
Yeah.
But to Max, you were gonna make, I think, I know the point you were gonna make, so I'm gonna kick it back to you on class
You
action.
can take it if you'd like to.
No, you got
No pride of ownership. No, what I was going to say was, I don't know when those clauses became in vogue, but plaintiffs' lawyers have adjusted to that, and the internet is the great democratizer when it comes to how these things work. Um, so you can put class action waivers and mandatory arbitration agreements in place, and you are correct, it will very likely stand up and stop a technical class action. But that may not be to your client's benefit. Um, First of all, on my own end, single plaintiff FLSA cases tend to go at a higher rate per head than a collective or class wage and hour will, because there's sort of a trade-off on that. You're going to have to get court approval, and the court's going to want to know that unless there's some, critical financial issue, people are at least walking away with what they were originally owed, free and clear. But the other thing is, employers tend to be on the hook. Those agreements typically stand up in an employment context if the employer is paying the arbitration fees. And because of the
That's a
onset
good
of the
point.
internet and search engine optimization, you then open yourself up to what I actually think is probably a worse outcome, which is mass arbitration. Because instead of a free federal court or state court that is adjudicating your claims and dealing with this, you are paying per arbitration to the arbitrator plus all the fees, and you're still defending all of these claims, which likely have merit if some firm has taken the trouble. So my favorite example of this was Chipotle was really beating its chest when it won a motion to compel arbitration. The plaintiff's firm just turned around and signed up like hundreds and hundreds and hundreds of class members, to the point where Chipotle then ran back to court to try to sort of undo what they had done to themselves, in creating this outcome and claiming a hardship. So unless employers think they're not going to pay it, there was a decision in Illinois in a federal court, I think semi-recently, a couple years ago, where I think it was Samsung, and not in a wage and hour context, tried to get out of paying the arbitration fees that it had required by virtue of the agreements, and the court said, nope, you're on the hook. You wanted it, you got it, you're paying. So just, depending on the size of the employer, just be careful what you wish for, because you may get the arbitration and class waiver, but you may be sorry that you did.
Yeah, that's something, that's a really great point, because I often find from a business perspective that whether it's you're going to mediation, arbitration, conciliation, or litigation, oftentimes it's going to be a wash in terms of the cost and all that. And that personally, I think less experienced attorneys really buy into that whole thing that arbitration's faster and less expensive and blah, blah, blah. And I don't think it's categorically that way.
No, I think for a discrimination case or something where a jury could really launch a bad actor, like then and only then is there the possibility it saves the client exposure and money, because they can contract to limit some of the discovery options that people have. Amit and I have worked on arbitrations where um, the rules that were agreed in the contract were like, it's decided on the papers, 10 interrogatories, 10 requests for production, a final submission with page limits, and the only motions that get to be filed are with the arbitrator's approval or with good cause shown, something like that. And because it's arbitration, it's a lot looser concept of what is
Yeah, evidentiary
required and
standards. Yeah.
procedurally. So, yeah, if you're afraid of a jury really launching your clients for something bad they were doing, I mean, A, maybe consider getting them to stop or working with them, but B, yeah, in that context, it might save you. But in a wage and hour context, I think I'm to the point where I think it's a bad idea, because you're going to end up paying more in the long run.
Yeah. Thanks. I'm gonna go move into a different topic. what if a business overpays an employee or needs to make a deduction from wages like a garnishment?
So it circles back to what Max said earlier too about missed time or disciplining employees by docking their pay. And what Helen said too, which is you've got to be very careful about state and federal law. So there's FSLA issues, but there's also state law issues. On overpayment, the safest route there is to get something in writing from the employee. Otherwise, there's always going to be a risk that if you dock their pay, now you've implicated some potential state law, local jurisdictional issue, or the FLSA. From a wage deduction or garnishment standpoint, typically that's going to be through a legal process. You're probably going to get a court order, and then that'll be the appropriate way to really begin that process.
Well, let me ask you this. I mean, you can do a garnishment without a court order? Like if I've seen this, like, I think the big one is furniture stores. Like furniture stores send to a lot of employers, like, your employee owes us money for this, like rent to own or something like that.
I would be, yeah, Helen, I think you were going to jump in too.
What I was about to say is actually this happened, not your exact example, Chuck, but it happened to me recently where a business client of mine contracted with a vendor, and actually they got a notice from the Illinois Department of Revenue. Okay, so this is state taxes that we need you to withhold. Okay, now I know that's a business to business, is a little bit of a different example. But where it has come in with my clients is more like Amit was saying, which is the wage garnishment from, let's say, a collection, like let's say they owe a creditor some money and there's been a wage garnishment. Or often, so that is one big scenario. Another one is child support.
Oh yeah,
There is actually a court order. You do have to garnish if it fits the criteria. And there's a whole calculation, and it's very, very confusing, but essentially the employee has to make a certain amount in order for the garnishment to be effective. So what I tell my business clients who contact me when they get these garnishment orders is talk to your employee first, because they will know if the government is going after them, if child support is going after them. So speak with them. And if they get, yeah, I know about it or whatever, more likely than not, it's probably not fake. And then step two, and even if the employee denies it, I still say step two is that make sure it's a real court order. Look it up on the circuit court system, see if there's a case number, see if there's a real order. If there is, call the other side and verify it. And then if it truly, truly is a real court order, you need to comply. You need to comply, because then you, meaning the employer or the business, can be hauled into court for violating a court order, a deduction order, a wage deduction order, a child support order. So yes, so vet if it is accurate, and if it is, valid, and if it is, then you do need to act.
And to add to that, I think companies want to be conscious of, if you don't have a court order and you get something from just like a business, making sure it's valid and what the proper steps are, because there's a lot of fraud and those types of things, phishing things that happen. So to Helen's point, you definitely want to talk to the employee. You definitely want to check to make sure it's accurate, and then figure out what the appropriate way to approach it is. You don't want to just start deducting pay and now open yourself up as a company to a wage claim.
And also, I think from an HR standpoint, it's just good HR management to check with your employee first and discuss it with them first, since that's going to affect their compensation. So,
Yep.
it just makes more sense. Max, this is always a good one because of the confusion, because of the mixed answers and confusion. What about maintenance of records? How long do you maintain? Should a business maintain records for?
So again, you want to know what state you're in and how the state laws might be different, because there are wage and hour laws in Illinois where there's a 10-use statute of limitations. I'm not saying this applies across the board in the whole country, and most states don't have that, but if you know that,
Even in Illinois, it only applies to one particular statute.
exactly, and it's one that like non-employment litigators have no idea even exists most of the time. The Wage Payment and Collection
Even
Act.
some employment litigators, I've known, they don't know it exists. So
Yeah, sometimes I can't tell if they're just playing dumb and saying it's a breach of contract and putting their fingers in their ears when I say that, or they really don't know that it's out there. But no, I mean, under federal law, usually the baseline is you want to think about 2 to 3 years, at least 3 years for payroll records. CBA agreements, sales purchase records, what have you. Once again, the FLSA is really,
CBA, you mean collective bargaining or?
excuse me, yes, I shouldn't speak in
Okay.
shorthand on a webinar like this. Collective bargaining agreements. Often
Actually,
those,
or whatever the term of the agreement is, so 4 years, or whatever, because
right,
some
I was going to
agreements
say
are
you can
longer.
contract for longer record keeping for various reasons. You know, and the types of records you need to keep, again, check your state law, but under federal, you know, think full name, social security numbers. There's a lot of reasons why you might get audited on those issues, especially nowadays. Addresses, birth dates, if somebody is younger than a certain age, I think 19, sex and occupation. And then here's where the rubber hits the road and where those record keeping requirements we talked earlier are really a good practice if you keep that stuff, because you can be really courting danger if you don't. The time and day of the week when a work week starts, how many hours those folks work each day, the bases on which wages are paid. So, what is the rate of pay? Um, Daily or weekly earnings, overtime earnings, any deductions or additions you make. Because again, remember, you can, if you're paying certain premiums, you may affect the hourly rate such that if you pay overtime, you need to act on that. And actually, I think Apple recently in the last year got whacked hard on that. They had offered some stock options to certain employees. And I don't know how far along the case has gotten, but they were sued for overtime pay issues because they were not factoring those options into the
Interesting.
hourly rate of pay. I don't think the case is resolved, but it was at an early stage and it had survived some sort of emotion practice. So it was moving forward. So even the big boys are not immune from those slip ups. And you also want to think about total wages paid and dates of payment. But again, this is not comprehensive, and I would encourage folks to check the regulations and their employment folks because it's all written down there, and these are, you know, not to be taken in place of actual legal advice.
Great, great disclaimer there. Hey, we're at the top of the hour, so I'm going to throw this out to all of you, the three of you. This is another question that often comes up with businesses. So employers discipline employees who don't take breaks or who work beyond 40 hours without permission.
Yeah, and I can see why, because there are some laws that require breaks. So, for example, in some jurisdictions, there are laws about you can't work more than, let's say, a certain amount of time without eating a meal. And
Yes.
so, you know, employers do need to allow their employees the opportunity to have that meal break, for example. And if the employee keeps working through and doesn't take the meal break, then the employer can be in trouble. And so they might say,
Yeah.
look, you must take this. And also, there are employers that don't want to pay overtime. Okay. So they will say to the employees, don't work overtime unless we authorize it, because they know they have to pay that, they have to pay overtime. And so there are many policies and procedures and handbooks that will say you are subject to discipline if you don't take the mandated breaks and if you work overtime without permission. And that is perfectly legal and perfectly acceptable because the employer is afraid of getting in trouble. Because if the employer says, well, you know, again, it's one of these strict liability kind of things, you know, the employer could say, oh, I gave them the option to take a break, but they wanted to finish what they were doing. And the government's going to say, no, that doesn't cut it. You're in violation of the employment laws.
Anybody else? All right. Max, you were going to chime in with something? Okay.
No, I got nothing. Helen is always
All
so
right.
comprehensive.
You looked like you were getting ready there, so all right.
I hadn't heard myself talk for a few minutes and I was starting to get the shakes.
Okay. Yeah, withdraw from that. Okay. All right, we're at the top of the hour. So thank you, everybody. Thanks to our panelists, Max, Helen, Amit. We're going to be back for webinar number 4, the impact of communicable diseases, including coronavirus on the workplace. That'll be on May 7th at 2 p.m. So we're not doing one. My understanding is that we're not doing one in April, but we'll be back on May 7th, 2 p.m. Central Time for communicable diseases.
Isn't that
Oh, you
also
have a
Is it
ADA?
the tech one this year again, or is it communicable diseases again? Did
Well,
we?
I thought we switched up. Did I say the wrong one?
Yeah,
You
I
said
think it's
communicable
ADA. Isn't it
diseases, and I
ADA?
thought that was sort of a COVID.
Yeah, I know we got rid of like the overall COVID thing, but I thought we were still doing, oh, maybe I looked at the wrong one. I'm sorry.
I think it's
So we're,
ADA, Americans with Disabilities Act, disabilities taking time off, and I think communicable diseases might be wrapped into that.
Yeah, I
okay,
think
so that's on
number
that's on
4
May
is
7th.
absence and medical issues.
Thank you. Okay, sorry about that. May 7th at 2 p.m. Central Time. So see you guys there. Thanks, everybody, and take care. We'll see y'all then.
Thanks, Chuck.
Bye, everyone.